Negotiable Instrument Act 1881, Chapter 1, Preliminary, Section 123. The Negotiable Instrument Act 1881 came into the force on 1st March 1882. Under Negotiable Instrument Act, Bill of Exchange is defined under Section 5, Chapter 2, Notes, Bill and Check, Section 4 to 25. Which written instrument signed by the maker is a promissory note. Mr. B, I will pay you 1000 rupees on demand. Which is not a negotiable instrument. Bond. Which of the following is not a bill of exchange? Shares. The term check in the electronic form is defined in Negotiable Instrument Act 1881 under Explanation 1A of Section 6. The term negotiable instrument is defined under the Negotiable Instrument Act under Section 13. If a minor draw, endorse, deliver, negotiate an instrument, such instrument is binding on all the party to the instrument except the minor. The term check in the electronic form is defined in the Negotiable Instrument Act 1881 under explanation of the Section 161A. Negotiable instrument is defined under Section 13 of Negotiable Instrument Act. In which section of the negotiable instrument public holiday is explained? Section 25. A sign instrument in the following term. Which instrument are promissory note under Section 4 of NIA 1881? I promise to pay B or order rupees 500 to be paid on demand. Under Section 11 of NIA, a promissory note, bill of exchange, check drawn made in India and made payable to drawn upon any person resident in India, inland instrument. If the endorser sign his name and add a direction to pay the amount mentioned in the instrument to a specified person, the endorsement is said to be endorsement in full. As per the provision of Section 26 of NIA, a minor may draw an instrument so to bind all the party except himself. In the case of promissory note, which is not a negotiable, no notice of dishonor is necessary. Which one of the following is true about inchoate instrument? It is incomplete and blank negotiable instrument. At sight under Section 21 of Negotiable Instrument Act 1881 means on demand. Which term is used to describe an instrument which is not discharged even by the non-presentation of instrument to accept for the payment? Bill of exchange. Which provision of the Act deal with the payment in the due course? Section 10. Following is not an essential condition for the applicability of Section 8 of the Act. The article must be movable property. Which one of the following negotiable instrument required acceptance by drawee before the payment can be demanded? Bill of exchange. What is a term used to describe an endorsement in which endorser exclude his own liability on the negotiable instrument in the case of dishonor of the instrument? Sans recourse instrument. Chapter 3. Parties to the notes, bill and check. Section 26 to 45. The term legal representation in the Section 29 of Negotiable Instrument Act 1881 include executor or administrator. Which provision of the Act deal with the effect of declaration? Section 35. Negotiable Instrument Act make a special mention of three instruments, namely check, bill of exchange, and promissory note. Chapter 9. Noting and Protest. Section 99 to 104. Which provision of the Act lays down that foreign bill must be protested for dishonored if so required by the law. The place where they were drawn is Section 104. Chapter 10. Reasonable Time. Section 105 to 107. In determining the reasonable time for the purpose of negotiable instrument, public holidays are excluded. Under the Section 138 of the Act, territorial jurisdiction does not arise on the following place from where the notice to pay the amount is issued. Chapter 13. Special Rule of Evidence. Section 118 to 122. As per Section 18 of Negotiable Instrument Act, presumption is regarded to the date of a negotiable instrument is that every negotiable instrument bear a date was made and drawn on such date. Negotiable Instrument Act 1881 provide for making which one of the following presumption of as special rule of evidence until the contrary is provided: that the lost promissory note, bill of exchange, check was duly stamped. The presumptions under Section 118 of the Act do not include presumption as to time of acceptance. In which one of the following case the Supreme Court held that rebutting statutory presumption under Section 118A and 139 of the Act, the evidence adduced on the behalf of complainant could be relied upon? Goa Plate Limited versus Chico Ursula D. Sujal. Chapter 14. Cross-checked. Section 123 to 131. What is the meaning of payment of check? Cross specifically. The banker on whom the drawn shall not be paid otherwise than the banker to whom it is crossed, or his agent for collection. Chapter 17 of penalty in the case of dishonor of the certain check for the insufficient fund in the account. Section 138 to 148. What is the maximum punishment under Negotiable Instrument Act? None of the above. Chapter 17 contains Section 138 to 142 was introduced in Negotiable Instrument Act by Act 66 of 1988. How much time it gives to complainant to dishonor a check? 30 days of intimation of dishonor. The offense of dishonor of check exclude strict liability, absolute liability means all. What are the defense available against the proceeding under Section 138 of Negotiable Instrument Act? Absence of legal enforceable debt, or literally absence of legal notice for 15 days, lack of jurisdiction. That there must be specifically allegation regarding the role played in each the director, then only they are liable for prosecution under Section 138 Negotiable Instrument Act. In which one of the following cases the statement was made? Todd Engineer Limited versus Nagarjuna Finance Limited. The effect of the notice under Clause B of Section 138 of Negotiable Instrument Act is the payee forfeits the right to again present the check for payment. For the purpose of attracting the provision of Section 138 of Negotiable Instrument Act, a check has to be presented to a bank within the period of 3 months from the date on which it is drawn or within the period of its validity, whichever is earlier. As per section 147 of NIA, every offence punishable under this act is compoundable. Mens rea has no place while determining the pillion liability under section 138 of NIA. This statement is correct. Section 138 of NIA deal with punishment for dishonor of check, in which court the complainant has a file appeal against the order acquittal under section 138 of the act. Court of session. Which one of the following court empowered to try the offence relating to dishonor of check for insufficient etc under the Negotiable Instrument Act 1881, Judicial Magistrate of First Class. Power of the court to try similarly given under which section? Section 148 of Negotiable Instrument Act. Section 143 of Negotiable Instrument Act. Every trial under section 143 of Negotiable Instrument Act shall be conducted as expeditiously as possible, and endeavour shall be made to conclude the trial within 6 months from the date of filing the complaint. Section 141 of Negotiable Instrument Act deal with the offence caused by the companies. Court can take cognizance of offence punishable under section 138 of Negotiable Instrument Act upon the complainant in writing made by the payee. Under section 138 of the act, complainant made from the date on which cause of action is arises 1 month. Under section 138 of the act, maximum term of imprisonment is 2 years. Which one of the following section of NIA empower a judicial magistrate of the first class or metropolitan magistrate try offence relating to dishonor of check for insufficient etc? Section 143 clause 1. Written complaint should be made to the court from the date and the cause of action within a period of 30 days. Which one of the following section of NIA 1881 deal with the offence committed by the company under section 138? Section 141. To constitute the offence under section 138 of Negotiable Instrument Act, within how many days check should be presented to the bank from the date on which it is drawn? 3 months. In relation of section 138 of Negotiable Instrument Act 1881, in with the punishment for dishonor of check. Under section 143 of NIA 1881, the trial shall be made to conclude after filing a complaint within 6 months. Who is entitled to make complaint of taking cognizance of offence under section 138 of Negotiable Instrument Act 1881? Only the holder of the check. The complaint for taking a cognizance for offence under section 138 of NIA has been made within 1 month from cause of action. Who was the drawer of the check to be prosecuted for non-payment of the check due to insufficient fund under section 138 of Negotiable Instrument Act 1881? Only human being, only corporate body, only a firm, all. The offence of dishonor of check for insufficient etc of fund in the account of drawer is punishable within imprisonment for the term which may extend to 2 years, or with fine which may extend to the twice the amount of the check, or with both. The check can be presented within the period of 6 months from the date on which it is drawn, any number of time. If a person committing an offence under section 138 of NIA, a company of the following shall be deemed to be the guilty of an offence A person in charge of the a person in charge and responsible of the conduct of business of the company as well as the company. A complaint against the drawer of the check, dishonor, and insufficient fund must be made within 60 days of the receipt of the information of the bank regarding the return of the check as unpaid. The maximum sentence of the fine which JMFC is imposed for offence under section 138 of NIA Act is twice the amount of check. Appeal against an order for acquittal by JMFC represent the offence under section 138 of NIA can be filed in Court of Session. A demand notice in writing has been given in the drawer of the payee under section 138 of Negotiable Instrument Act 1881 after receiving the intimate from the bank of dishonor of check within a period of 30 days. Who of the following is not liable for prosecution under section 148 of Negotiable Instrument Act 1881? Any person nominated as a director by virtue of holding any office, employment, and in the central government. Any person nominated as a director by the virtue of holding of office, employment, or in state government. Any person nominated as director by the virtue of the holding of office, employment, and central and stated collected finance corporate all. No court shall take cognizance of any offence punishable under section 138 of NIA unless complaint is made from the date of acquittal of cause of action within 30 days. For the purpose of section 141 of NIA, company means any corporates, any firm, any associates of individual. Cognizance of offence, section 142 of NIA. Offence of companies and firms. Section 141. Dishonor of check for insufficient funds. 138. Power of the court to try the case summarily. 143. Punishment under section 139 of NIA is respect of any of the check issue and discharge of any debt. Section 138 of NIA Act provide a penal provision in the case of dishonor of check if the presented to the bank within the period of 3 months from the date on which drawn within the period and validity whenever it's earlier. Which one of the following is a proviso clause of section 130 of NIA require the notice of 15 days in the case of failure of payment of check? Clause C. The presumption regarding the dishonor of check on the production of a bank slip is rebuttable. An offence under section 138 of NIA tried summarily, but the court imposed on accused a sentence of imprisonment for 1 year. The sentence is legal. For the purpose of section 141 of NIA, company does not mean and include for proprietor concerned. It should not be defense in the prosecution for offence under section 138. Drawer had no reason to believe when the issue of check that the check may be dishonored or presentment for the reason stated in the section. This statement is true. Which one of the following circumstances will attract the provision of section 138 of NIA? all of the above circumstances. Check dishonored due to insufficient fund. Check returned by the bank unpaid on the ground that account is closed. Check returned to the bank unpaid due to the stop payment instruction by the drawer. What is the presumption under section 138 of NIA? That the check was issued for discharge of any debt and liability. Under Negotiable Instrument Act, how many days are serving of notice of demand of drawer? The cause of action arises against drawer if he failed to make payment under 15 days. Under Negotiable Instrument Act, for filing of complaint under section 138 of the Act, essential condition is the check was returned for insufficient fund in the account. The cognizance of the offence under section 138 of NIA can be taken by the JMFC having territorial jurisdiction at place where the check is dishonored by the bank of which it's drawn. Which section provide that offence under the Negotiable Instrument Act is compoundable? Section 147. Offences under NIA Act are triable by Judicial Magistrate First Class. The provision of no court inferior to the Metropolitan Magistrate or Judicial Magistrate of First Class shall try the offence punishable under Section 138 is existed under Clause C of Section 142 of NIA Act. Which section of NIA 1881 exclude the defense that drawer has no reason to believe when he issue a check that it may be dishonored for the presentment of the reason stated in section 138 of the Act. C. Section 140. The trial of the offence under section 138 of NIA Act, the provision of section 262 and 265 of CRPC shall apply. Section 143. For the purpose of attracting the provision of section 138 of NIA Act, a check must be presented to the bank within the period of 6 months on the date which has been drawn within the period of its validity, within the period of 3 months from the date on which it is drawn. Which of the section of NIA Act 1881 provide where a person is nominated, directed by the company by the virtue of holding any offence and employment in the central government of the state government, as the case may be, shall not be held liable for the offence under section 138 committed by the company, the provision 2 of section 141 clause 1. Which one of the following is correct statement of law as per section 138 and 142 of NIA Act? A check to be presented to the bank within a period of 6 months from the date of drawn within a period of its validity, whichever is earlier. Notice within 30 days of the receipt of information that bank regarding return of check as unpaid has served upon the drawer demanding the payment of the amount of money. On the failure of the drawer of such check to the maker payment within 15 days of receipt of the notice, the payee or holdee of the check has to file complaint within the 1 month thereof. The delay in the filing of complaint under section 138 of NIA Act can be condoned by under section 142 of NIA Act 1882. Which one of the following judgment has Supreme Court held that only those court within whose territorial limit Droy Bank is situated would have jurisdiction to try the case for offence under section 138 of NIA Act 1881. Dasrath Roop Singh Rathod versus State of Maharashtra 2014. In which one of the following cases Supreme Court held that provision of Section 141 of the Negotiable Instrument Act 1881 does not condition and prosecution of the company is sine qua non for the prosecution of the other person. The liability of directed offense etc. is vicarious will flow from the liability of the company of the firm. Muhammad Ishaq Gulsani versus Raj Mouli. The court shall not take a cognizance of any offence punishable under Section 138 of Negotiable Instrument Act 1881 unless the complaint was made within 1 month. The Chapter 17 was inserted in NIA 1881 by the amendment of the Act in the year 1988. Cognizance of offence, Section 142. Power of court to try summarily, 143. Defence which may not be allowed in any prosecution under Section 138. Section 140. Presumption in the favour of folder, Section 139. Complaint against offence under Section 138 of NIA Act and instrument must be in writing. Offences under NIA are cognizable and compoundable. Amendment in NIA made in 1988 has been introduced an important provision relating to dishonour of check. Before initiating the criminal proceeding of dishonour of check, within how many days the receipt of information about dishonour should be paid of the check issue is noticed, 30 days. The appeal against the order of acquittal passed by the judicial magistrate first class in respect of offence under Section 138 of NI Act will be lying to the Court of Session. Check issue under the same transaction, dishonour of complaint, and receipt of all the check is maintainable. If a prosecution for offence under Section 138 of the fact had no reason to believe when he issue a check that the check may have dishonored of the presentment shall not be defence. Can a magistrate order an investigation of an allegation of offence under 138 of NIA? No. The sentence can be awarded to convict for the offence under Section 138 of NIA is imprisonment for term which may extend to 2 years and fine which may extend to the twice the amount of the check or both. Chapter 18 under Section 118 of NIA Act, what presumptions shall not be made? The holder of check received the check for discharge of fine, debt and other liability. The maximum amount of fine which can be imposed under Section 138 of NIA is twice the check of the amount. Miscellaneous. Under Negotiable Instrument Act, promissory note can be drawn. The minimum period of no time limit is fixed. Instruction of stop payment remain valid for none of these. Section 100 of NIA deal with protest. Which one of the following is true about the bank draft? It is very much like a check. Which one of the following is not a negotiable instrument? Undies. Which option is correct where the complaint under Section 138 is filed at premature stage before expiry of 15 days prescribed with a demand of notice of 15 days? Cognizance can be taken afterward when the course of action is arise. Under NIA, how many times a holder of check can be present before a bank during the periods of its validity? Any number of times. A person who received the NIA in good faith for the valuable consideration is known as holder in due course. All checks are bill of exchange, but all bills are not checks. True. In order to rebut the presumption under section 138 and 118 of NIA, accused must may rebut the presumption on the principle of the preponderance of probability. Under NIA, the instrument in writing contains an unconditional undertaking signed by the maker to pay certain sum of money only to or in order of certain person or to the bearer of the instrument is promissory note. A bill leading is neither A nor B.